Segueing back to the SCOTUS, the Supreme Court decision today, gutting the Voting Rights Act. Back during the 2012 election, the Department of Justice stopped the state of Texas from executing a strict voter ID law that was passed by the Texas Republicans in 2011. At that time, the law was so restrictive, and I would say that the one area I think that the Department of Justice has been good under the Obama administration has been civil rights, and particularly in issues of voting. Attorney General Eric Holder at that time called it a poll tax. The Texas ID law was so restrictive that essentially no IDs, no student IDs, only a special non-driver state ID or a driver's license would work. It was estimated, according to Texas's own figures, that somewhere between 600,000 and almost 800,000 registered voters, that's between 4 and 6% of all registered voters in the state, lacked the necessary ID to vote. As you can imagine, the vast majority of those were either people who were poor, disproportionately minority. A lot of those people either had no reason to have a driver's license, they didn't own a car. They lived in areas where it would be literally 250 miles to go to a state office to get the non-driver's license. The hours of the, I don't know what they call it there, the DMV in Texas were such that you would have to miss work. And so the law was rejected by the Department of Justice. That decision was upheld in court, stating, simply put, many Hispanics and African Americans who voted in the last election will, because of the burdens imposed by SB 14, that was the law passed by the Texas legislature, will likely be unable to vote in the next election, and thereby blocking the law. So it was never implemented because of Section 5. Within moments after the court struck down Section 4 as unconstitutional, essentially hollowing out Section 5 of the Voter Rights Act, the Texas Attorney General said in a statement that the state's voter ID law will take effect immediately. It was already passed by the Texas legislature. Now that the action to prevent that law from taking effect under Section 5 has been negated, the Texas AG says that law will take effect immediately. I imagine that's going to go right to court. You've had a court rule on it, but it was under the auspices of Section 5 and Section 4, so this is going to have to be relitigated.